Mr. Davis, will you state your name for the record?
David Davis.
Thank you. Your Honor, I am asking for an adjournment for plea negotiations, and I do have information regarding the bond violation that I want to address with the court.
Yes.
Okay. Your Honor, I did receive that yesterday. I contacted.
Okay, right out the gate, we're diving into bond violation territory. Pay close attention, hear the mention of cocaine tests and scram tethers isn't just courtroom lingo. This is the foundation of how the judge will decide whether Mr. Davis gets another shot or a jail cot.
Contacted Mr. Davis. We went through that. I will note he's on a scram tether. My information that there's been no violation. I, of course, assume that the court's biggest concern is this positive test for cocaine. The first one, Mr. Davis is forthcoming. I mean, he does not disagree that both tests are positive for cocaine. He does not deny use prior to being arraigned. But of course, that second test on the 21st is of issue. Mr. Davis is taking this matter very seriously. He is employed. He did reach out to Dawn Farms yesterday to enroll in outpatient treatment.
Now here's a critical moment. Mr. Davis is trying to show he's taking recovery seriously. Outpatient enrollment, assessments, scram monitoring. But let's be real in court. Words are cheap. The judge will be looking at actions, and those drug tests are receipts. What do you think? Is this enough effort or too little too late?
Did provide documentation to opposing counsel, confirming that he did a screening and confirming that he is scheduled for his assessment on Friday, September 12th at 11 a.m.
But he doesn't have a medical marijuana card either.
No, and he reports that he has stopped use. I don't know. I think that's roughly like 3 weeks. I don't know if that's, or maybe actually less than, about 3 weeks, if that is still in his system or not. But he reports that he has stopped THC use. But I think at this point, I would point out that he's had at least one test that he did not test positive for cocaine. He's on the scram tether, confirming that he's had no alcohol use. And he's working on getting into treatment and doing the right thing and showing the court that
he's not in treatment.
He has intake scheduled for the 12th. He did an assessment yesterday. He's beginning outpatient on the 12th next Friday.
I will adjourn his probable cause conference to the 11th, 2025, 9 a.m. But prior to his intake, defendant's remanded to the Washington County Jail.
And there it is, bond revoked. Translation: Mr. Davis is going straight back into custody before his intake. This is a classic example of how timing in legal proceedings can make or break your freedom. Mr. Wearing orange.
Your Honor, would you like a copy of the confirmation of his treatment for the file?
Why don't we bring that up on the 11th?
Okay.
Okay, because I just don't want to keep it in here.
Sure.
If I don't have.
I'll do that. Thank you, Judge.
Paul Brown, Deputy Chief Public Defender, being written on behalf of Mr. Buckner, who approaches the podium. Mr. Buckner, state your name for the record.
Eric Buckner.
Thank you. Your Honor, today's the date and time set for a probable cause conference. At this time, we are going to respectfully request that the matter be set for a preliminary examination.
Both cases.
Yes, please.
The discovery is complete on both cases.
Yes, sir. Best of our understanding, it is.
People have their witnesses available on 16.
Yes, sir.
Preliminary examination in person will be set September 16th, 2025, 9 a.m. That's before Judge Perry on both matters.
Thank you, Your Honor. May we address the issue of bond?
Okay. Go ahead.
Thank you, Your Honor. So the last time we were here, we wanted to make sure that Mr. Buckner could take...
This bit might sound like boring logistics, but it's huge. MRIs and GPS tethers don't play nice. And yes, you heard right. The defense is asking the judge to let the defendant temporarily remove his tether to get medical scans. Real question, did courts make medical exceptions, or is that opening the door to abuse? Drop your take in the comments.
Appointments. He had medical appointments. He's got an arm that is deteriorating. So he needs to be able to have MRIs. You tasked myself and the prosecutor to try to get together and work something out. At the time, we had indicated that for employment, he was doing deliveries but he didn't have any hours. So he asked us to be together, work those out, and then provide an order to the court. We were unable to do that because up until recently, Mr. Buckner was unable to give us specific hours for the employment that he needed to do, for the deliveries. But you did say that as long as he let community corrections know when his appointments were, that he could go ahead and do that, and we put that in order. The development since then is that they told him that he cannot do the MRIs he needs to do with the tether on. Somehow that interferes. So what we're asking is for two things. First, that he be allowed to be able to remove the tether when he goes to do his medical appointments, so that they don't interfere with the MRIs that he needs to be able to do. Second, that he have 4 hours per day, either from 8 to 12 in the morning or from 1 to 5?
5 to 9.
I'm sorry, 5 to 9, so that he can be employed. He has to be able to be employed. He's got a daughter that needs to maintain, a house that he needs to maintain. He's out on home confinement because the court obviously didn't feel he necessarily needed to be in jail. But if he's going to be out of jail, he's got to be able to maintain himself and his family. So we're asking not that you release him, not that you not have any oversight, but that he just be allowed to be out to be able to work while he's on home confinement, and that he be allowed to have substantive medical care.
Response from the people.
Your Honor, I don't want to get
View that escalated fast. The judge denies the bond motion, clearly irritated by the defendant's courtroom attitude. Pro tip if you're in front of a judge, every look and body language cue is being judged. This isn't just law, it's performance. And today, the curtain just dropped hard.
the way that I just haven't seen any documentation related to it. I know that defense counsel states that he had previous conversations with the last prosecutor, at least as it relates to the medical. Certainly don't want to object to that. I'd ask for documentation related to employment prior to allowing that out there.
We did that numerous of times with the estimates. So
You sent me a list of hours that you were asking for something from there.
I've been on tether for a whole month. So we've been trying to figure this out. I don't know.
You don't be talking now because you're not talking so that the court can't hear us. So don't do that. So what they're asking for.
We're not going to have an issue with the medical, provided the appointment is provided.
Right.
The tether needs to be removed for that purpose. That can happen, and I'd sign an order to that effect. I'm still worried about this employment, giving him sort of this window to, he's going to have that attitude when he just asked him to follow that instruction. Oh, we're not doing that. Motion for bond reduction is denied. I'm done. You talk to your client about why that just happened. My bailiff tells him something, he needs to just respond appropriately, not give that face. Oh, no, I'm done. Thank you.
All right. Thank you, Your Honor. We will have whatever sufficient orders the court needs.
Court calls the case, People versus D'Angelo Simmons. Better check himself and don't slam my door. Oh, is this Mr. Brown also?
Yes.